Доброго дня, шановні учасники п'ятої.
Good day, dear participants of the 5th International Scientific and Practical Conference. My name is Irina Zhevtobriukh, and it is my pleasure to announce that the 5th session of this conference is about to start. For those who haven't joined to us, the rules are that all our interventions will not last longer than 15 minutes. First, panelists will deliver a presentation, and then we have questions and discussions, and also you can use the toolbar in order to have Q&A session. These options can be used both by panelists and the attendees. And if you want, you can leave your questions in chat. From the agenda, it is evident that we will be hearing about case consideration by courts of specific categories of cases. We will have greatest pleasure of hearing from extraordinary panelists, renowned lawyers, people who I know personally and respect as renowned and qualified professionals. And first, who I have the honor to introduce is an extraordinary person, a very determined and efficient Ihor Dashutin. He is justice of our chamber. He is Dr. Habilitas and he is a professor. And moreover, he is very much honored colleague from our chamber. The floor goes to you, dear Ihor, to cover this important topic. Thank you so much, our charming Irina Zhevtobriukh. It's a big pleasure to be here, and I'm a little bit humbled by such introduction on your part, and I want to thank everyone for arranging this event, and that will have a positive impact on our system that must be ensured, the tax system must be ensured even during wartime. Raisa and her assistants helped to arrange the conference that was attended by highly professional experts in terms of taxation system. And also I want to thank for a chance to be here today and to a little bit share with you my research in terms of virtual assets. Recently, you have all been hearing, and it's impossible to ignore, and it's impossible not to notice that more and more cryptocurrency exchange is done, and we must take into account that although the first 50 Bitcoins were issued as back as January 2009, the cryptocurrency term has been widely used since the publication of Greenberg in April 2011 in the Forbes journal. As far as application and implementation of the relations in society is concerned about cryptocurrency, this is a multifaceted challenge. On the one hand, we have a question of whether it's feasible to have this regulation of such social relations. On the other hand, it has to do with the exchange of values and goods, and that's why we have some gains. That then arises a question at least about taxation. In turn, we have an issue of the influence of cryptocurrencies on different spheres. And first of all, we must understand what is the essence of this cryptocurrency nature of this feature, because when taxation takes place. We need to figure out whether cryptocurrency is taxed as such, or whether we need to convert it to some national foreign currency whatsoever. Here, we must also have due regard for evolution of respective regulations in Ukraine. That's why the first attempt was made by the National Bank of Ukraine. We had explanation in terms of the use of cryptocurrency in Ukraine, cryptocurrency Bitcoins. It was as far back as in 2014. And the Bitcoins has to do with real value, and legal and natural persons cannot be used as the payment method because it contravenes the legislation of Ukraine. Also, in the letter of 2016, the National Bank of Ukraine mentioned that it's a monetary surrogate that does not cover real value, although now, or actually a little bit later in 2018, it was recognized that this letter is no longer relevant and it's no longer in force. So since 2016 till 2018, Bitcoin was used as money surrogate. And according to the National Bank of Ukraine, monetary surrogate is any documents different from the national currency of Ukraine in order to have payments in commercial exchange, except for the currency values. But we in general can have some idea about the legal framework of the National Bank of Ukraine in terms of the cryptocurrency. It has to do with monetary points different from the one by Ukraine, issued not by the National Bank of Ukraine in order to have, and which is not a valid currency asset. So cryptocurrency as a monetary surrogate is not a monetary value, is not issued by the central bank, and at the same time, it's impossible and prohibited to use it when making payments. On the other hand, an external manifestation is that there is a document like monetary notes. And if we use this last sign, we must take into account that it not only has to do with just document, but it's electronic digital document. And cryptocurrency has specific legal form in order to use which to have respective terminology. The document as a sign is monetary elements which legal nature and legal form has been there for cryptocurrency in Ukraine from 2014 till 2018. Later in 2017, the Parliament of Ukraine got a draft 7183 that proposed to define cryptocurrency as an object of property that can be contained in blockchain and as data. In 2017, there was received another draft law 7183 bis 1 that provided for defining the cryptocurrency as decentralized measure of value that functions as maintaining the value, and that has to do with mathematical calculations, is the result, and has cryptographic description. At the same time, cryptocurrency for legal regulation is considered to be a financial asset.
In the same 2017, the National Bank, the National Securities Commission, National Commission for Regulation of Financial Institutions expressed their opinion that the legal nature of cryptocurrency prevents recognition of them as means of payment, any currency, any electronic money, securities, or any money surrogate. And another link of this chain is the draft law on amendments to the tax code. In 2018, it was for virtual assets in Ukraine. Their taxation, it's 9083. That's the number of this law. And there they suggested that cryptocurrency in the form of tokens was used to preserve and exchange value. But the tax code Ukraine had to be amended with the virtual recording and entry that can be used as a means of exchange, the unity of exchange, or a means of preservation of value. And virtual assets in this context are cryptocurrencies and token assets. By virtual assets, they mean cryptocurrency and token assets, and they suggested amendment for the tax code with the following logic. This is a digital unity of exchange for the distributed register and entries in digital forms with a cryptographic entry. In 2018, they had a draft 9083, which was offering some amendments to the tax code of Ukraine. And let me just not dwell on this one because the draft laws were then revoked and withdrawn, and there was the pause followed an interval for legal regulation of this issue. Another stage of legal regulation was the law was revoked, and then some legal uncertainty governed for a while. Then 2061 was proposed, and that was a follow-up to that idea of 1083 of the year 2018. And there we could see the crypto assets as virtual assets in the form of token, and to be generated and distributed through the register. Another stage for the circulation regulation was adoption in 2019, the law of Ukraine on prevention and combating money laundering, funding of terrorism, and mass destruction weapons. With a virtual asset being used as a notion, it is still it's standing the digital value that can be traded digitally or transferred for investment and payment purposes. The beginning of the next and the last so far stage of cryptocurrency regulation was in 2020, 3637, the draft law, which like its successors had no notion of token on crypto asset, cryptocurrency. For that matter, there is just one notion there. And according to the previous draft law, cryptocurrency was identified as crypto asset on non-tangible digital asset. The virtual asset is cryptocurrency or tokens as assets. So the virtual asset according to 3637 had 4 versions at least. The latest one was on the 17th February 2022, the final one so far, and that's how the law was adopted on the 17th of February 2022. Generally speaking, we have the virtual asset encompassing not just cryptocurrency, but other non-tangible assets for civil war law and having value attached to them according to the Civil Code of Ukraine. Money, valuables, and securities, and other property, results of intellectual and creative work, works and services of any kind, and other non-tangible and tangible assets, according to Section 15 of the Civil Code as material goods. We have results of virtual activity, creative activity, creating transactions, and civil rights of ownership being generated. The law of Ukrainian virtual assets, according to which the circulation of such virtual assets is regulated, but according to the law of Ukraine of the 17th of February 2022, and according to provisions of Section 15 of the Civil Code of Ukraine, virtual assets include not just so much cryptocurrency, but any kind of electronic valuables or values. We cannot but mention also the technical and legal achievements of that law on virtual assets, some of them unprecedented, even in the draft before adoption. So summarizing, we have to say that today we still have the regulation 2014, the explanation of the national interpretation of national bank on bitcoins as virtual currency, and the draft 2461 is still pending with the virtual asset as a specific type of property. And we have to say that we have the effective law on prevention, combating, legalization of process of crime and illegal activities, funding of terrorism and mass destruction weapons, according to which we have the virtual assets that can be traded digitally or transferred or be otherwise utilized for payment or investment or end investments. According to the final visions of 2074 draft, it is suggested to amend the law on prevention, combating. I was referring to, and the version that is in conformity with the definition of virtual assets. The law itself, 2074, has to come into force only from the day of come into force of the law in Ukraine on amendments to the tax code pertaining to the same set of notions. The study is much broader than I can possibly discuss here. I published that in the legal judicial gazette, where you can look it up. The topic is still being researched, finalized, analyzed. There are no amendments yet to the tax code. Thank you very much. Thank you for this introduction to the legal status of virtual assets, which are gaining much popularity in our modern life. Taxation, declaration, and even inheriting the virtual assets is a matter for adjudication and disputes where we will have to participate in the nearest future. I expect our next speaker requires no special introduction because after all those years of her professional activities, she reached such level of appreciation, recognition, high profile that it is unattainable for many. But personally, I would like to use this opportunity to add some words of appreciation. This is a young lady, being an established professional, doctor of law, senior lecturer. She is a member of our team, and she is a friend of mine. She's very young still. Natalia Bajitska, who is a judge, justice of our chamber, and she will now discuss the discretionary powers, rule of law, and taxes in the aspect of finding the proper balance. Thank you very much, Irina, for such a generous introduction. I'm even more nervous now because I never expected such compliments even before I talk. Dear colleagues, every branch of power is assigned with interpretation. Their power is choosing between functionary and rational interpretation, and the judicial intervention is possible according to the division of powers. If the executive branch is within the scope of such powers, the courts are not supposed to interfere, and it all rests with the executive branch. Their discretion cannot be substituted by court for application of their discretion, using their judicial discretion. The role of judge in the legal system with democratic values is in preservation and protection of distribution of powers. Discretion exists because there are laws with more than one option for interpretation, and discretion through the prism of works of Rosenberg, Dworkin, we can say that it is possible to state the following. Rosenberg talks about the primary and secondary discretion. Primary discretion, in his opinion, occurs when and where the agent has a choice of decision and is free from limitations. So any kind of primary discretion in finance. And Dworkin is interpreting one form of strong discretion, two forms of weak discretion. So the rule of law is supposed to remove the number of discretions for societal governance. Some words hike to a lesser extent, dynasty, to a bigger discrete. I say that, argue that this is in conflict with the rule of law. Davis is pointing to the extravagant position discretion is impossible in a modern administrative state. The rule of law is not just in removal discretion, but all in making sure that the discretion is well defined and implemented. So the discretionary power exists from the Aristotle's times. With the legal instruments, Aristotle would call it rectifying the legal and just. Discretion means achieving the goal, and the actor empowered has to be limited by the agency powers delegated by the society and the rules of the society, with the decision making taken into account different values as a consequence, creating flexible management. The doctrine of administrative law can mislead us when they make believe or pretend that judicial power is equivalent to political neutrality. Great respect for public institutions results in alliance with the judicial power with the executive power. This is a bad service to the system of check and balances and any direct responsibility for the quality of governance. According to the government crisis, and he stated that according to the legality principle recommendations of the Committee of Ministers for the EU members for good governance, we can read that executive agencies have to act within the law. They cannot apply any discretion or arbitrary action, even exercising their discretion. So the agent of power can act only if the legislation provides for that, and exclusively with the goal that created this. There are recommendations for the form of administrative powers in the it's Article 17, Clause 1. The administrative decision should be laid out clearly and in an apprehensive, in a fashion easy to apprehend. Every individual decision, according to Article 26, has to be justified with the grounds, legal and factual grounds, so that laid some groundwork for this decision, especially for the individual rights. According to the Justice of Supreme Court of the U.S. Williams, who expressed this that if discretion is absolute, person always suffers. Absolute discretion is more destructive for liberties than any kind of human invention. And absolute discretion, like corruption, means the end of liberty, the end of freedom. So we have to minimize the absolute discretion as much as we can, finding the means for that. The absolute discretion can be abused when they say in literature and treaty. The illegal use of administrative powers for illegal goals different from what is designed for the position in question, or irrelevance, lack of conformity, correspondence with the considerations that should be taken into account when exercising the administrative powers, and not taking that into account, that can be authorized. The irrelevant argument can make execution of powers illegal. And the lack of good faith. If the agent acts in bad faith, it is very difficult to prove. Discretion should be reasonable and should be in compliance with the law. And discretion should not be arbitrary. At the same time, according to Portuguese Professor Maria Gloria Dias Garcia, the administrative justice is not limited by guaranteeing human rights, and is justified by the necessity to defend public interest and guarantee the balance of individual rights and the public interest. This is not a popular opinion. In fact, there are many opponents to it. Professor Gloria Diaz Garcia has them, but according to Judicial Somerset County Council Experts Hearings case, that is the case with the majority of court decisions. When they review their decisions, they do not look into the merits. They do not ask themselves whether this decision is correct, and even less, much less, they ask themselves whether they themselves arrived at such a decision. The only question is whether the body being reviewed had it as the only legally possible solution for the problem in hand. Lord Donaldson, Secretary for the Environment, mentioned the role of the courts and players. It's like team playing. It's up to them. The referee is only involved in the dispute resolution when some players violate the rules. Then the referee can stop the match and rectify the situation, but it is not up to him to express his views on the actions of the players and the best way to behave in such situation. Even less, this is violation of rules, whether they are supporting position of one of the players. In sophisticated tax systems of the British one, there remains situation when tax law is not clear.
Наслідків. тлумачення норм права.
That's why interpretation of the legal rules can deepen uncertainty. That is the opinion of many English academia members. And they mention that there can be decisions that are not similar to overly established practice. For example, in case HCBC Holding,
Зазначено,
it
такий
was mentioned that this ADRs, American ADRs, were issued under New York legislation, do not have fiduciary interest in the parts. It can have far-reaching conclusions for the market, but the tax service of the Great Britain confirmed that in order for the tax purposes to be established, it will still be interpreted as fiduciary position. And the position mentioned that the market still continues. So it's unrealistic to expect that there will be any tax system functioning without just giving discretion to the tax authorities. That's why it is generally established that the body needs discretion for the tax system. At the same time, the only body who has the powers is the parliament and has different discretion points. But the parliament cannot and should not delegate these powers fully. It is relevant to ask a question: how far should the discretionary powers go, and how they should be controlled? For example, Great Britain says that this discretion can be divided into three groups: especially delegated discretion powers in the legislation, for example, whether it's necessary to have more bodies of the company or a specific fine, then specific one on withholding taxes. It's set by the parliament, a specific part of tax legislation, for example, discretion for determining whether the I'm very sorry, one moment. So discretion in order to determine whether it's possible to rely on the situation when the taxpayer gets a favorable position after the tax check. And it is determined within legislation in some cases, such a prolongation of the deadlines for the group of companies. That's what we're speaking of. General discretion is discretion covered by section number 9. And here it is said that the judge is responsible for collecting and administering taxes, and for that, and there can be done what is considered to be generally acceptable. And for that purposes, the tax body publishes different technical instructions and issues authorizations, extra statutory concessions. European legal culture uses a three-element purpose of proportionality, and these animals are reasonableness, proportionality, and necessity. Necessity here means the choice of the respective field of the expenses of the person, and the proportionality is, it means that there is a balance between public and private interests. So there is a connection between the principle of proportionality and abuse of power. First has to do with element of power. There can be instruments in order to carry out specific tasks, and authority cannot do some actions on its own. The difference is that abuse of powers shows that this was not used appropriately, and then it puts a question the purpose itself, whether this is possible by law. The law connects some provisions to specific tasks, and if these goals go beyond, it undermines the measures applied. And that's why concept of abuse of power influences not only actions but also the purpose as not related with respective powers. And classical decision is a decision of the 1933. It's the decision of the France that had to do with public conferences. You can find it out on your own because we are running out of time. And another aspect is the proportionality, which is balancing values and interests, especially in specific formulas. So we see this abuse, for example, in English notions. It's references to axiology, not taking into account due circumstances and lack of due and proper balance. In more specific points, it isn't covered by abuse, but rather they show that there is limitations of violations of the margins of appreciation. However, these criteria of the acting extra virus is similar, and this marginalization of traditional concept of the abuse of power is evident in terms of classic structure. And when we have the classical idea in proportionality is indeed very similar in judicial review of the acts and institutions of the European of the CJU. And here we know that it has somehow of feedback when then claimants need to choose different ways, and then we have in general issues covered with the abuse of power. Another practical aspect here is the fact that this ground for complaint requires deep and thorough review of the legality of the actions of the body, because it has to do with fundamental violations. For that reasons, the analysis of these mistakes is done at the end of the argumentation, that rather, for example, takes a decision to cancel the act based on other decisions. So abuse of power by other criteria of review, including proportionality. Some authors say that in such a way, when reviewing discretionary powers of the bodies of the European Union, the case law of the EU shows protection of main rights and responsibilities that have to do with proportionality principle, and increasing the importance of proportionality criteria means that there will be eradicated the classical doctrine of irrationality. To finalize, if the abuse of discretionary powers means using them in contravention to the purpose set, how the authority gave these provisions, we have the key problem of finding the criteria of legality and feasibility. So here comes the next problem. How do we understand the feasibility as legal fact, the most important one, and the one outside the law and in different situations? Because this criteria of legality is used, and we have also mistakes in the use of discretion by violating the legal norm, and the trust to that legal obligation, and when there is when doesn't meet the ideas. So the question is how much it is possible to have via judicial check. It is based upon assumption that the legislative body gives the powers with a specific end, and the most evident one is when sometimes delegated powers have nothing to do with the ones set in legislation. So I now want to conclude by saying the words of Professor of Lisbon University, Anna Palmdurado, when she says that there should be legal argumentation, and when it's impossible to generate the only correct decision. I agree with that. I'm sorry for going a little bit beyond my time. Thank you for a chance to deliver an intervention here. I wish us the victory and to fight this horrible enemy as soon as possible. Thank you so much for such a comprehensive and deep intervention for this very thorough understanding of doctrine. So now going to the next speaker, we must remember the scale of his personality. A very well-known advocate, member of the Bar Association, and candidate of legal sciences, Semen Hanin, and also very renowned author, literature, publisher. He has, with his presence, influence on the development of the law in Ukraine, and his opinions and his feedback is given as key number of addressees, and that's how he, in most effective manner, can speak of his public presence as an effect, as influence on the development of law. Semen, please, the floor is yours. Thank you so much. Good day. Dear colleagues, the issue of consequences after the order or decision of the tax authority has given is quite painful and challenging. The resolution of the ruling of the Grand Chamber that you can, numbers of which you can see right now on the screen, issued in 2021, where the Grand Chamber has a little bit deviated from the Supreme Court of Ukraine since 2015 Supreme Court judgment, did not put a final and finishing touch, but on the other hand, there were many points to have. We must also have a look at a separate opinion of the justices of the Supreme Court dated 8 September 2021. In all the rulings of the Supreme Court that are being pinpointed here, the fact of violation of Article 79.2 of the Tax Code of Ukraine, the court recognizes, especially meeting the requirements of this article, complying with this article, gives the right to the authority officials to start documentary off-site inspection. That is, the court in each point agrees that the order for the check was delivered and that the check was done with violation of the legislation in force. Yet, in the opinion of the Grand Chamber of the Supreme Court, in case we see that the authority was admitted to conducting a check based on the decree on its conducting this order as an act of individual purpose, means that it's challenging is not efficient and effective way of protecting the taxpayer's right, because cancellation of or quashing the order cannot renew the right violated. That is how it cannot be subject of specific claim, but it can be a ground for the claim to render unlawful the actions taken after such an examination or check. At the same time, the grounds for quashing such decisions are not just every violation made when appointing and conducting such an examination. It can be only the ones that influenced and that could objectively have influenced the correct conclusions arrived at by the authority that is doing the examination, and respectively the reasons and the legality of such a decision. Not agreeing with the resolution of the Grand Chamber of the Supreme Court and supporting the separate opinion of the justices of the Supreme Court chamber, I want to say that Article 19 of the Constitution of Ukraine says that the authorities and local governing bodies their officials are obliged to act only based on, within their purview, and in a way provided by the Constitution and laws of Ukraine. That is, by their actions, the overseeing authority violated the Constitution of Ukraine. The fact of such violation is there, irrespective of whether there was an administrative authority admitted to check or no. Next, point 19 of Part 1, Article 4 of the Code of Administrative Justice that says that individual act is an act by the authority issued or adopted to carry out respective authorities in order to address specific persons, and the act of which is limited only to the persons assigned and is over when it has been complied with. Then we also have another provision of the Code of Administrative Justice of Ukraine. Each person has a right, in the manner established in this code, go to administrative court if it thinks that the decision, act, or omission of the authority violated its rights, freedoms, or legal and legitimate interests, and asks to protect via rendering illegal and quashing individual act or specific provisions thereof. It is this paragraph that has no prohibition to challenge individual act that is over when it has been complied or carried out. And the Grand Chamber gives reference to two decisions of the Constitutional Court without using any other reasons. About reference by the Grand Chamber of the Supreme Court to specific reasoning part of the Constitutional Court of Ukraine dated 1997, the 23rd of June, in the case 335-313, it provides a quote from the decision of the Constitutional Court of Ukraine, and it says that by its nature, non-regulative legal acts do not establish general rights and the scope of activity, but these ones are directed at a legal entity or individual, and after they are complied with, they are no longer relevant. But it's only a part from the paragraph of that decision. Here you can see the full text of the paragraph as it is in the Constitutional Court of Ukraine judgment. Based on the specific point of the transitional provisions of the Constitution of Ukraine, legitimacy is covering legislation and extending the jurisdiction of the Constitutional Court of Ukraine on whether acts meet the Constitution of Ukraine before entering into force of the Constitution of Ukraine only in respect of legal rules and regulations, given that by its nature, non-regulative legal acts, unlike regulative ones, establish not the overall conduct, but specific points for a specific individual or legal entity that are used on a one-time basis, and after they are done, they are no longer in force. So if we read, then this decision has to do with only coverage of jurisdiction of the Constitutional Court of Ukraine onto the legal acts that were adopted before the entry into force of the Constitution of Ukraine. And this paragraph contains only general definition of the issue normative legal acts, and it is similar to respective article of the Code of Administrative Proceedings. There is a very big difference between the opportunity to challenge within administrative justice of acts of individual manner that are over when they are complied with, and extension of jurisdiction of the Constitutional Court of Ukraine to legal acts adopted before the entry into force of of the Constitution of Ukraine. Moreover, as it is followed from that decision, jurisdiction of the Constitutional Court of Ukraine that is adopted before the entry into force of the Constitution of Ukraine is not covered to those non-normative legal acts that were not yet implemented or that were not that this defined term is not over.
Його розуміє Велика
We
Палата.
understand this decision according to the Grand Chamber's interpretation. We cannot issue individual acts which are not enforced at this point. For the reference of the Grand Chambers to item 5 of the decision of the Constitutional Court of Ukraine, the 22nd of April 2022, the Grand Chamber quotes the legal acts of non-regulated character have to be applied to individual persons and then exhaust their effect. So let's approach the decision itself. And the presidential decrees, a number of such and such, are legal acts which are not regulating, non-regulatory nature and individual action. Mr. Verbuling is dismissed from his position of the Secretary of the Parliament. Haiduk and Rushanov appointed according to the Secretary of the Council and Deputy Secretary. That was about individual natural persons and for personal application, and after the implementation or enforcement, they exhausted this action. Mr. Haiduk and Rushanov were dismissed subsequently by the presidential decrees as well. So according to the legal position of the Constitutional Court in decision of the 14th of November 2021 on official registration, jurisdiction of the Constitutional Court of Ukraine covers only effective statutes, item 5 of the recital. So the this does not fall under jurisdiction of the Constitutional Court of Ukraine. And the jurisdiction of the Constitutional Court of Ukraine specifically covers the effective regulatory and legal acts. That stems from this. What follows that their jurisdiction does not cover the non-regulatory legal acts at all, even the effective ones, which have not exhausted their action yet and or their effect yet. The individual acts for administrative adjudication cannot be appealed against, even inclusive ones which have exhausted their effect. So the Grand Chamber of the Supreme Court made a wrong decision, in my opinion, on the necessity to review the 27th of January 2017 resolution as a deviation. According to Article 2.1 of the Code, the disputes result in legal transactions for public law for the interest of individuals and the rights of the companies protected against the actions of any institutions. So the inspections with violation of the effective legislation, that is an essential violation of the rights of the natural persons or legal entities, violating Article 17.16 of the tax code for presence at the inspection, providing explanations of the issues that crop up during such inspection and so forth. And I would like to draw attention to another thing. This is Article 74, Clause 1.
Уваги докази, які одержані з порушенням порядку, встановленого законом. Тут доречно звернутися також до практики ЄСПЛ щодо принципу плодів отруйного дерева, а саме, що докази, отримані з порушенням встановленого порядку, призводять до несправедливості процесу в цілому, незалежно від їх доказової сили. Так, у своїй постанові у справі 826, 24, 815, 15 Верховний суд у складі колегії Касаційного адміністративного суду зазначив, вказана позиція неодноразово висловлювалась Верховним судом та відповідає доктрині під умовною назвою «Плоди отруйного дерева», сформульовані Європейським судом з прав людини у справах Гевген проти Німеччини, Нечипорук Йонкала проти України, Яременка проти України, відповідно до якої, якщо джерело доказів є неналежним, то всі докази, отримані з
So all of the evidence thus obtained will be of the same relevance. If the evidence is obtained with violation of the regulations effective, that leads to the lack of justice in the proceedings themselves. According to the doctrine, we have to examine not just every means of evidence, but all the chain of the interrelated pieces of evidence which stem from one another and are functions of the previous ones. The evidence as poison fruit of now. We can have grounds that such evidence cannot be obtained with lack of information that is provided illegally or obtained illegally. The decree on inspection should be handed over to the manager or any other acting leader. This is not required by the effective legislation. The inspectors try to put pressure on the manager, for example, in the cases of tax seizure of property. According to this seizure, as a result of it, we can have bankruptcy. So the inspectors usually admit it. And the appeal takes a lot of time. So if you deny the appeal for the inspection after the admission, that violates private and company interests and the principal tasks of the administrative adjudication. Summarizing, having analyzed the norms of the tax code with a balance of private and public interest, the conditions set for adoption by the regulator, decisions to conduct inspections, the deputy on-site inspections and irregular inspections, that should be based on an order on such inspection with the necessary entry made on the date and the time, and that should be done as according to the established procedure. In compliance with 78.11 and 79.2 of the tax code of Ukraine leads to recognition of the inspection as illegal and lack of legal consequences for such an inspection. Thank you very much for your attention. Thank you, Semen. I am very happy to see a like-minded person. I support and maintain the same kind of position, but the majority of the Grand Chamber's judges take the opposite, different stance, and so please, different standing. So Nicole is one of them. He's one of your opponents. Can you hear me? Yes, we cannot see you, but we, oh, sorry. Well, at least you can hear me. Semen, thank you for your interest in presentation. And I would like to put a question to hear your opinion on the following topic, because basically any kind of motivation can be imperfect or made more perfect So the analysis of the Green Chamber's decision that you presented in your discussion, it deserves some consideration, but I would like to hear your opinion on the following matter. Do you think, and if so, then how the administrative adjudication in terms of efficiency for protection of rights of persons, taxpayers, can be achieved in the case when based on an order where legality of this is subject to some doubt. So appeal of this order or decree as a separate merit for a claim. How court decisions can lead in such situations to effective protection of rights? I would like to know your opinion on the matter. Good afternoon, dear colleague. Thank you very much for this question. It's a very relevant one. We all understand that this issue is super complicated and otherwise wouldn't have had so many discussions around it. But my personal opinion is that the mission of administrative adjudication is to protect person against state. We all understand that tax authority has a whole detachment of functionaries. They do it routinely every day. They cannot be excused when they make a mistake, and their powers should be executed. This should be done according to the letter of law. In this situation, tax authority represent the states, and it should be a model of execution and compliance with such a commitment. If representatives of the state violate laws and the Constitution of Ukraine, in some instances, their actions cannot have any legal consequences, any legal effect in any situation. Now about the decision-making form. Perhaps in this decision, there should be said that it's not just the instruction to inspect should be cancelled, but the consequences also of such an inspection, the results of it should be made void. Perhaps we should improve the tax code on this hand or some other pertinent statutes. But in this situation, it would even worsen the situation because the decision, unfortunately, the Grand Chamber legalized the illegal actions, in my opinion. That is to say that if we weigh the first position, the second position, I think the first position is that the illegal actions should not be followed by legal consequences. I like this position. I'm inclined to take it. I hope I managed to answer a question. I think this is supposed to be interactive, and after the presentations, we have some time for the Q&A. So let's switch to another presenter. We would like to greet for this conference Volodymyr Reshota, Professor, Chair of Administrative and Financial Law of Ivan Franko University, Doctor of Law, Professor, who will discuss appealing decisions on refusal to register in the single register of tax nets. I hope that you will be as systemic with this report as with the sources previously, the sources of law. Thank you, Irina. And I would like to have my presentation shared. Mikhailo, dear judges, international guests, participants of the conference. Thank you for the opportunity to discuss this. And this is a very important aspect for the category of cases and tax disputes. Well, this is not just stemming from my judicial experience, but also my experience as a defense lawyer. In some cases, for appealing refusal to register the settlement, making corrections to the register of tax notices. I would like to discuss this in a concise fashion, not to trespass on anybody's time unduly. So in tax transactions and the cases reviewed in administrative adjudication, well, when we discuss this refusal to register such documents, and we have some cases when the administrative courts are approached in order to find the truth and protect the violated rights. This sphere is extremely important for the business agents and taxpayers because based on item 201 of the tax code of Ukraine, and we have to have the tax notice tax invoice registered, and this is a tax invoice registered which is used for levying tax on the tax loan. And there are many cases, well, there are very important cases and frequent cases on the position of the regulatory tax bodies in order to improve the procedure for the issues of suspending the suspension of the registration. They used the cabinet of ministers adopted a special resolution 1165 of the 11th of December 2019, which was adopted the suspension procedure for registration in the single register and review of the complaint and discussion and the correction calculation of the 12th of December 520, 2019. The decision to refuse registration for the correction settlement of tax invoices. And the renewal of such procedure, in my opinion, had in mind to downsize the number of disputes and to provide the opportunity to submit such documents in an extrajudiciary fashion, providing the necessary documents to register such documents and the correction settlements, correction. The lack of efficiency was caused by some reasons, the stance of the tax authorities on certain issues, and that's led to the recognition of necessity to make those disputes judiciary, and taxpayers apply to courts to defend their interests and protect it. I would like to mention several reasons why the problem is the problems observed in this very area. I would like to say that there's this lack of customized approach for the commissions of the regional and central level. The customized solution should follow the principle of every single act being authentic and singular.
І платник податків повинен розуміти, які саме
And the
документи
taxpayer should understand what documents are required and what is necessary in order for his documents to be registered and in order for his tax invoice to be accepted in the respective register. So now we'll have a look at the fact that pretty frequently tax authorities set it forth in specific decisions. You can see the first part of this decision on registering or refusing to register tax invoices and other documents in the Unified Register, where under paragraph 5 of the order under number 520 that I mentioned obliges the tax authority to provide respective documents for the Commission of the regional level to adopt a decision on registering or refusing to register. Next one is we see here that we have not only when we have refusing to accept the tax invoices, sometimes the authorities consider that it's enough to have separate reasons, for example, no
або ж відразу усіх пунктів.
contracts or addenda, or all of these positions, and it is not always that due attention is given to the points in this decision about additional information and additional information where it has to be indicated specific documents. So if we look at all these decisions to refuse registering them, we can have an impression that it's the same decision when the tax authorities just take the list and all of these documents indicate that they're not there, although some documents are submitted and foreign trade contracts cannot be there in general. So it all leads to the fact that taxpayer does not understand what specific documents he or she needs to provide. If at that stages after stopping registration and using this chance of administrative challenge, the taxpayer just submits all the documents that he or she thinks he or she has, and all these ones that are individual, and we have this public dispute, and then the plaintiff has to go to the administrative court.
І відтак, однією з таких
Therefore, one of these problems is that
орган, це безумовно не
not
стосується
all grids are filled in by the tax authority. At least from the decisions that I have analyzed, we can see that sometimes there is no the specific and individual information that should be there, that should be mentioned. And all of this in turn leads us to the conclusion that these requirements are not met of the Code of Administrative Proceedings and Law on Administrative Procedure that was yesterday mentioned, and it is considered that the tax authority should do more in this regard. Also, I'd like to draw your attention also to the need to have specific indications that have to do with registering in respective documents of Ukraine. Also, some legal positions of the Supreme Court, in particular, underlining underlining the fact that administrative procedures and adopting individual acts have to be transparent, have to be clear and understandable, and there should be a substantiated decision. It is something that helps preclude undue actions on the part of the state. And the recent decision provides an opportunity to protect public interest and also reduce the number of claims that would be arising and landing in court. This will unburden the judiciary. Another ruling of the Cassation Administrative Court of within the Supreme Court says that confirming the correct manner of submitting a declaration has to do with specific level of risks to be understood, whether there is a risky operation and what the reasons are, and also whether a given taxpayer falls within risk categories. Also, it's point number 8 about tax information, about tax authority, that also is an attempt to understand what kind of information gave rise to an idea that this taxpayer is a risky one. Also, another reason that I would like here to point is that decision at the Commission of the Central level upon the consideration of the case and upon having the final decision is also not reasoned, and we cannot see why this claim was not adopted, what documents were lacking, but information is quite abstract, sometimes it's dubbed, and that's what we hear from the Commission at the regional level. And it's at the stage of preparing for a claim when there is not a clear understanding. So we'll now go further. Another reason, another issue I'd like to pinpoint here is that the Commission at the central level does not always take into account explanations and extra documents that were not submitted to the Commission of the regional level when registering tax invoices. But in my opinion, it is not the best position because it contravenes point 11 of the order on refusing to register such invoices, which says that the taxpayer has the right to provide explanations to the central authority that were not sent to the regional authority. Even later, when we have it claimed to the Commission of the central level, the taxpayer has a chance to provide his or her explanations and additional documents that should be taken into account by the Commission. And to finalize, I want to say that clear, foreseeable, and proper requirements and effective communication with taxpayers facilitate litigation related to the tax cases and will improve and support protection of taxpayers' rights. And this will be my last slide. Thank you for your attention. Thank you for having me here and giving me a chance to contribute. Thank you so much.
Дякую нашому шановному
We
доповідачу.
thank our wonderful panelists for a thorough analysis of what is in force now and specific issues of such a registration. Given the fact that our time is running fast, I will now introduce another colleague of mine, Vyacheslav Kohuliak, on the principle of setting local taxes, dues, and charges And when we list all the decorations and wonderful points of my colleague will take a lot of time, but I want to say that not only is he a judge of the Supreme Court, professor and doctor habilitus, but he is a very thorough, special, very good in his area, a very wonderful man, and he is very much respected among the judges. So, Vyacheslav, the floor is yours. Thank you so much, dear Irina, for introducing me. I will take into account requirements of the timing, and the fact that at 16 sharp we need to go to discussion. We must have a discussion within this session. That is why my address will have to do with principle of whether we have enough of the fiscal points when introducing local tax and customs. But I want to take into account some points that were mentioned when we were discussing section 3. So I would like to start with the fact that the budgetary system of Ukraine is built upon the due and proper division and allocation of costs among the communities and the citizens of Ukraine. I have now quoted the Constitution of Ukraine, namely Article 95, and in my opinion, this provision must be of the proper and most central position, both for basic and fundamentals of the legislation. Because after having this constitution set forth in the constitution, it introduces public governance in general. The Constitutional Code of Ukraine, upon the submission of the Cabinet of Ministers of Ukraine, on the official provision interpretation of Article 95 of Ukraine, and speaking of balanced budget in Article 3, has to do with the fact that the very wording the state aims to have balanced nature of the budget of Ukraine must be understood as the state striving when having the system, when adopting respective acts that may influence, can have due interactions between them, and when dividing such shares, they must take into account community needs and due conditions for a person's living. And the very wording the state strives to or is aiming at, it means the duty of the state and the aspiration of the state to direct its activity to some tasks specified in the Constitution of Ukraine. And in these Constitution provisions, we say that the principle of the budgetary system of Ukraine, and we have respective code of budgetary code of Ukraine provisions, establishes the principle of balance, and they must meet the respective budgetary period and respective provisions of Article number 9 sets forth impartiality and unbiased nature, according to which the budgetary system of Ukraine is built on fair and non-prejudicial allocation of the income that is gained from taxes. Yet we must take into account that the above-mentioned constitutional provisions are also embodied in the tax code of Ukraine. Here we have the principle that is named, whether it's enough in terms of fiscal nature. It must have the proper balance between budgetary expenditures and the budgetary gains. In the tax code of Ukraine, it is interpreted by the legislator through the balanced nature of such gains made to the budget. And we speak of whether it is fiscally enough as inter-area principle that has complex meaning for both budget and fiscal law. Here we should say that in the financial law, we are making an attempt to qualify fiscal laws into two groups. I will not read the persons and scientists who abide by this and who support this one, but we have tax principles and economically conditioned principles. So the tax law that also under which also falls the principle of fiscal, whether it's fiscally enough. And it was mentioned that economically conditioned principles of law are doing everything to have a due legal framework, so-called economically determined aspects within tax relations. Indeed, this principle is intrinsic to economic logic that need to be respectively and harmonized. Also, it is suggested to have the principle of whether it's fiscally enough, only economic nature of the tax that, unlike the lawmaking and law enforcement points, has to do with the administrative one. But we think that such emphasis only on economic points and moreover taking into account its lawmaking nature is different because this principle set forth in Article 4 of the Tax Code of Ukraine, it is based on the legal injunction that has to do with imposition of taxes and charges. And here we must say that the main target of this principle is the legislator and also other bodies of self-government and authorities that have the right of lawmaking initiative and are empowered to impose taxes and levies. For this category of entities, it is necessary to take into account that in order to have planned budgetary expenditures, there should be enough budget that is based on taxes and charges. That's why the principle of whether the fiscal nature is enough, it's not only about the income of the budget, but the one that would ensure proper conditioning of the state and of the territorial communities. It is also limitations of possible undue conduct of the authorities. That's why it cannot be done with improper impositions. And in this local taxes and levies, we must first of all understand that such local budgets can be viewed in two aspects. First of all, it's as organizational mobilization of financial resources and also a system of financial relations arising between the budgets of different localities about redistributing between budgetary structures that function in a respective category. And as we already heard, another challenge is the one that was especially relevant during the aggression of Russian Federation against Ukraine was imposing such taxes without the principles set forth in Article 4 of the Tax Code of Ukraine. We have the key issue here of whether the decision of the self-government body that changed local charges, let's for example, tax, for example, for movable property of a land plot indicated in the Tax Code of Ukraine, under which any amendments to taxes and charges and levies cannot be done 6 months prior to the budgetary period when they will be enforced. I will not go into detail about the opinions of the Supreme Court, especially, for example, the ones dating this year and early years. They are there in the presentation, so in case you want, you can have a look at it. You know the decisions of the court itself, but I would like to draw your attention to the following points. Just a minute, if I may. I would like to clarify that such legal regulations in fiscal and social sphere, especially in terms of state carrying out its functions, I'm saying of budget balancing budgets and expenditures on military service and social security. It's about ensuring also the requirements of the Constitution of Ukraine and proportionality.
For interference of the state into the affairs of taxpayers who were assigned to provide additional revenues, and whether there is any balance maintained between the public and the individual interests. I need 1 minute for implementation of the principles of fiscal sufficiency with the setting of tax rates. It is necessary to take into account the necessity to combine the principles of tax legislation, the social justice, and application of such principles, coordinating them with principles of the budgetary and tax systems to implement the constitutional legal principles of fair and unbiased distribution of the public good between the citizens and communities. I would like to thank you for your attention, for our colleagues, international experts, especially for expressing their sincere support and appreciation of Ukraine. Thank you very much. I would like to thank you, Vyacheslav, for your instructive presentation. We cannot but mention what is the trigger of the scale and scope unheard of previously, but we will have to improve our efficiency. This is our developmental tool to promote Ukraine and to approach your integration. I would like to say that for consideration of time, we have to confine this to the discussion that we had and put in writing in the chat box. So just in case, perhaps someone has very urgent questions, but in the chat box, I cannot see anyone.